Good morning to everyone. Madam Deputy Registrar, kindly open the matter.
Thank you, Judge. Good morning. Caribbean Court of Justice, Appellate Jurisdiction, on appeal from the Court of Appeal of Barbados, hearing of appeal in CCJ Appeal BBCV number 1 of 2025 between Massy Stores Barbados Ltd and Merton Forde. The members of this morning's panel are Madam Justice Raj Lee, presiding judge.
Good morning to everyone.
Mr. Justice Barrow.
Good morning, all.
Mr. Justice Jamada.
Good morning.
Madam Justice Onaniwu.
Good morning, everyone.
And Mr. Justice Ibo Osuji.
Good morning, all.
May we have the appearances, please? Thank you.
May it please the court, I am Michael Koeman, and with me is Ms. Ashley Edwards, both of Denton's Delaney, attorneys at law for the appellant. And present in person as a representative of the appellant is Ms. Dion Walcott.
Thank you, counsel. You're mute, Mr. Khan.
My apologies, Your Honour. Good morning, Your Honours. If it pleases the court, my name is Tariq Khan, and with me today is Ms. Michelle Forde, attorney at law. We act for the appellant. The appellant is in another room in this building. Sorry, the respondent. He's in another room in this building so that we can minimize any disturbance in the background.
Thank you very much. And good morning again to counsel. Mr. Koeman, I take it I hope I have the right pronunciation. Being a victim of wrong pronunciation all my life, I'm very aware of the importance. So I trust that I have it right. But you are for the appellant in this matter, Massy Stores, and we take it that you are ready to make your oral submissions before us.
Yes, Your Honour.
Yes. Please start.
Mindful of the fact that Your Honours may have questions for me, I take the opportunity at the outset to address a few matters that I don't want to forget. The first is a typographical error which though slight might have caused some confusion at paragraph 13 of our written submissions, where I say that this appeal addresses
13, just hold on, yes.
13 and 1-3.
Yeah.
In that first line, I intended to say that the appeal addresses 2 TWO primary issues.
Oh, yes. Thank you.
And in relation to paragraph 21, I carried with this one for some time, and I am now of the view that the concession that I make there, that the Privy Council in the Corrie case referred to the question as to whether or not there was just cause for dismissal as a question of fact. I am now of the view that that is incorrect. I shouldn't have made that concession. I think properly viewed in context, the Privy Council was endorsing those issues of fact which were properly left to the jury as to whether the facts occurred from which they could have inferred whether or not there was wrongful dismissal, and that is clear from the wording of the judgment.
Yeah. I believe that we have understood what you wish to say as to paragraph 21.
Thank you,
Yes.
Your Honor.
Okay, you may commence.
This is a relatively straightforward appeal dealing with a rather narrow but critical point of law, defining the scope of, in our view, the cause of action of wrongful dismissal. It is essentially the appellant's position that a growing line of authority in Barbados, perhaps with a view towards leniency, certainly in the views of the court, in the interest of justice, has expanded the traditional test to take into account what the court below in this matter described as a humanizing patina, such that the question before the court becomes no longer the simple one as to whether or not conduct by an employee is repudiatory, but it appears it introduces sort of a two-stage test The first, whether it is conduct which merits dismissal, and then further, whether it is so serious as to merit summary dismissal. And our position is that properly understood, that is not the test. And we're urging this court to review the law and express an opinion for the guidance of all concerned. And it comes.
Could you just, for my benefit, repeat the two prongs as you have stated them?
I understand the Court of Appeal to be endorsing a sort of test under which the court first considers whether misconduct justifies dismissal simpliciter, presumably including dismissal pursuant to the terms of the contract with notice, and then whether it reaches the standard such that the employer could dismiss without notice.
Okay, thanks.
In our view, the second.
Counsel, in
Yes,
that
sir.
context,
Yes,
when was the law of unfair dismissal introduced in Barbados? Remind me.
I believe that was 2012, Your Honor.
2012, before or after this case?
Before this case.
I see.
Well, before the Court of Appeal decided in this case, but it may well be that that cause of action was not available to the appellant at the time that this proceeding first commenced before the learned magistrate.
That point has not been taken at all in this matter.
As I understand it, no, Your Honor.
Yeah, and you were telling us about the two-prong test that my brother Justice Jamada mentioned. And what do you say is the flaw in that? As far as the common law in Barbados is concerned, and when we look at all those cases going back to the esteemed Chief Justice Simmons?
Yes, Chief Justice Simmons is mentioned in cases that dealt with the extent to which an employer did not conduct a thorough investigation and the likely consequences that flow from that. But in our view, that decision, particularly in the Williams case, often referred to in Barbados, is consistent with the traditional analysis because an employer who does not conduct a thorough investigation runs the risk that at trial, which is the point in time at which the court considers whether or not there was just cause for dismissal or not, it may be that what the employer thought just constituted just cause does not bear itself out before the court. But the traditional understanding has always been, and I think one that lent itself considerably to certainty at the point of trial, whether or not just cause or the facts that would have amounted to just cause were known to the employer, was the employee guilty of conduct that was repudiatory, entitling the employer to dismiss without notice. When we add the so-called humanizing patina, then as in this case, it becomes a matter of discretion, and there is room for parties to vary as to what would be conduct meeting the first limb short of the second limb.
Can I ask you a question? Yes. Because you started with the idea that you want this court an invitation to make some sort of statement on what should be the proper test, right?
Yes.
Would you accept that the common law in Barbados is in a constant state of evolution?
Indeed.
All right. Okay. So it's not fixed or static. And would you be of the view that if I'm speaking about the common law of employer-employee relationships that you're asking us to declare, would you be of the view that if an employer is considering the most severe action, for example, summary dismissal with no compensation, whether they should, in that test, now be included an aspect that allows for due process or procedural fairness, or however you choose to describe it. In other words, that there should be some minimum procedural standards that inform the decision-making process of an employer. Because the way you framed it is, for the moment, a choice between substance, right? the discretionary aspect you put in there allows the discretion as to whether or not the conduct justifies summary dismissal. And you can take into consideration everything. So I'm asking something slightly nuanced. If I need to clarify it more, I'm happy to do so. If not, I'll be happy to get your response.
Well, Your Honor, I did consider that question, and there are two jurisdictions that have taken it with a pair contrary approaches. So the approach that Your Lordship describes appears to have informed decisions in Canada. And by contrast, the UK expressly introduced a statutory regime that prescribes what procedure must be followed and requires an employer to act reasonably in dismissing. And we do exhibit a nice summary from the learned authors of not Harris, but
both Canada and the UK have introduced some minimum procedural standards. Would you agree?
well, the crux of my submission was that the test for wrongful dismissal in Canada does import this humanizing patina referred to by the Court of Appeal and the court below in this matter, as distinct from the UK, which has maintained a very sharp distinction between two causes of action, wrongful and unfair dismissal. And I'm recommending the second course because, in my view, in my submission, it lends itself much more to clarity, because there has always been sort of a tension between the traditional contractual analysis, and I think all jurisdictions in the common law system, at least of which I'm aware, have accepted that the law of employment should be couched within the general law of contract. And then the question becomes...
Yeah, so let's just pause and interrogate that a little bit. So would it then be that your statement is that the common law should be that an employee has no right to a hearing, and that as long as an employer is satisfied that there is a repudiatory breach of contract, something that is so fundamental, that is a basis for summary dismissal? Is that what you are suggesting brings certainty to the law and clarity?
Yes, sir.
All right, okay. So why is it then that even within that context, that is to say, where the employer is of the view that there has been a repudiatory breach, a breach which is so serious and so fundamental that it undermines the essence of the employer-employee relationship and justifies summary dismissal? Why is it that even in that context, an element of procedural standards cannot be included? What I am struggling to understand is, even if you keep that as the decision-making test, i.e. that the breach is repudiatory, what I'm struggling to understand is how is that inconsistent with an opportunity for an employee to be told, we have observed this behavior, we consider that this behavior is of a repudiatory nature, we want to hear these are the facts, we want to hear what is your position on this. And then after that opportunity, if the employer remains of the view that it is repudiatory, then they have the remedy. So that's what you say the choice is between two, but I'm struggling to understand why, even if you take your choice of the basis for summary dismissal being a repudiatory breach, why is it that within that choice you cannot have built in a fair or opportunity for a process, maybe a due process, whatever you want to say, for procedural fairness? That's what I'm hoping that you can explain for me. Why do you feel that has to be excluded for the law to be certain?
In my view, it would be ideal if we wish to grant procedural rights to an employee, and this amounting to a pretty stark divergence from the common law approach, under which, as I mentioned earlier, an employer was entitled to raise cause for dismissal which came to the employer's attention after dismissal. The fundamental question simply being whether, even looking backwards, at the point of dismissal, there was just cause or not.
I
for that
understand
question to be determined by statute.
But hold on. That common law comes from 1888. That has its roots in 1888, in which master and servant was the language, and a servant had to be obedient to a master. That was a very different historical, cultural context from the context of Barbados in 2025, a republic, a democratic state, which in your own constitution, you speak about the rights of people and so on and so on. This master-servant mentality of 1888 that says an employer can dismiss, and then later on, look at it. Is that apt? And should we hold on to that as the common law of Barbados today, or should we build in developing this law an opportunity for due process, which does not change the principle that you hold on to, which is, if there is a repudiatory breach, we can dismiss you?
So in my view, in couching the law of employment within the law of contract, what the court is essentially doing, the legal system, is assuming a level of parity between the parties as opposed to a hierarchy of master and servant. We are deciding that, as in any other contractual relationship, the parties have the right to determine their own bargain, and they may or may not agree to a process which must be followed before the relationship can be determined. They can determine length of notice and any other provisions. And the question becomes then whether the legislature considers that the special nature of this contract and its fundamental importance requires that additional terms be implied in. And this has been neatly done in the case of the Employment Rights Act, which does provide...
Mr. Koyman, on that point, that the legislator or the legislature in Barbados has now moved in the direction of the Employment Rights Act. That's still within, I know, the traditional dichotomy of common law versus legislation, but if we're speaking more broadly about a system, what the legislature in Barbados did with that legislation is still something done within the ecosystem of the common law, a common law jurisdiction. Do you agree?
I strongly agree, yes, Your Honor.
And can that be basically an indication of a way to go? The legislature will now be in a position to, they're not a court. They're not going to be rendering judgments, judicial precedents, direct decisions, and all that. That would take time to evolve into a body of law. They've done what they could do, which is precipitously, so to speak, introduce legislation in the system. Courts, is it a good idea or not for courts to say, well, the legislature has done this, maybe we should be inspired by what the legislature has done and implement these as rules in what we call the common law system of laws?
And indeed, courts have done that, particularly in relation to enhancing common law principles. But to the extent that we'd be considering the question of whether we should set up a procedure to be followed, which would necessarily require limits, steps, etc., to be followed in all cases, at least as a general rule, I would submit that that would be better dealt with by Parliament. And when we contrast the procedural steps to be followed in dismissal for the purposes of an unfair dismissal under the Employment Rights Act, I think it becomes clear how useful it is to have a legislative regime impose itself there rather than a judge-made system.
But this would not be, would you call this purely a judge-made system if the legislature has done something and the judges are following the legislature in that regard and say, well, the legislature, what they've done here makes sense. We can borrow, we can be inspired by what the legislature has done. Would that be, in your view, purely judge-made process, or perhaps judge-made process inspired by the work of the legislature?
I think taking inspiration from the legislature in relation to a common law remedy would be a bit precarious. I mean, I'm certainly not in a position to dictate to your honors what kind of decision you can
Why
make.
is that? Why would it be precarious?
Given that radical changes in terms of rights granted to parties, in our view, would be best determined by the democratically elected body, and the courts having the overarching duty to interpret those rights as they have been passed and ensure that they are consistent with the constitutional principles under which all the legal principles find themselves established.
Mr. Koyman, I'm struggling really to understand this, because the common law is not fixed and immutable. Agreed?
That is true.
All right. Theory of common law is we declare the law that was always there. It's just the judges see it and declare it. The question that you have asked us to ask and answer is this. You say this case invites this court to ask and answer this fundamental question. What should the common law of Barbados be in relation to the summary dismissal of an employee? Agreed?
My question is a little bit narrower, because you can have summary dismissal in the context of an unfair dismissal, but the question before this court is in relation to wrongful dismissal.
All right, fair enough, fair enough. I accept that. What should the common law in Barbados be in relation to the summary dismissal, wrongful dismissal in Barbados? That's the question that you've asked us to ask and answer. Agreed?
Yes, Your Honor.
And are we, as a matter of proper jurisdiction, common law jurisdiction, allowed and duty bound to declare what that common law should be in 2025?
Indeed, Your Honor.
That is not an undue exercise of judicial power. That is the historical power of the common law system, and you have invoked that and invited us to do so. All that our brother is asking is, should a court where the parliament and the people of Barbados have given an indication of what they think the law should be, look to that and ask itself, should the common law come up to speed? Or is it that the parliament is going to declare this is what we think the policy should be, and courts should ignore that and say, well, that's not relevant. That's all that's been asked. Should we look at what the parliament has done in a similar area or analogous area and ask ourselves, is this something that we should look at when we respond to this invitation to declare the common law in 2025? What is so improper about that?
I don't think that it is improper to consider the spirit behind the Employment Rights Act. And I think it is clear that, as you've mentioned, our society has evolved beyond the status quo as it was understood when the law of master and servant, as it was then called, was first promulgated. But that is a different question from importing the tests that have been set out after consideration by the legislature in a different kind of cause of action. And I stress this because the law of employment is part of the law of contract. And that general principle that parties ought to be held to their bargain undermines the entire legal system as far as contract is concerned. It's the basis upon which commerce is determined. So there has to be a holistic and principled determination that, notwithstanding that fundamental understanding of parity and parties being held to their bargain, there's some special feature of the employer-employment relationship that justifies the court in abridging it in some overarching way, which will affect all contracts of employment, whether they be with a managing director, a cleaner, etc.
And how do you
understand
the intervention that we are discussing? Do you think it is changing the principle that a repudiatory breach allows for dismissal? Do you think we're trying to, is that what this conversation about? Or is this conversation about including within that framework a process that allows some fairness?
I believe it changes the test as to what is repudiatory. I think it makes the hurdle a bit more difficult in practice for an employer to overcome.
Why is an opportunity to hear the other side? Why does that change the test of what is the test of what is repudiatory is whether the breach is so fundamental that it undermines the contract. That is what is repudiatory, isn't it?
Yes, and I believe
I'm still struggling to understand why an opportunity to be heard, how does that impact the test of whether it is repudiatory?
So 2 points. The first is that this decision does not turn on whether or not there ought to be an opportunity to be heard. I don't understand that to be a live issue before this court at all. But generally speaking, dealing with the question whether there ought to be dehumanizing patina, which would empower a court to look at that and other factors to determine whether or not an employer was justified in dismissing, I'm saying that the first limb of that two-part humanizing test undermines the traditional analysis because it imposes a first hurdle that the employer must supersede in order to justify dismissal simpliciter, and then he must go further. So it raises tiers of misconduct which were otherwise unknown to the common law.
Mr. Quinlan, you said that undermines the traditional understanding. I believe your concern there is not undermining for the sake of undermining. Your concern there is it is undermining something, a system, because that will result in chaos. It will result in injury, result in something not good, not just undermining. I assume that must be your premise. Now, assuming that I'm correct in understanding that to be your argument, you've also indicated that, well, there are two systems and you're urging us to follow the British system or the English system. The contrasting system you pointed to is the Canadian system, where they have imported a version of what you would call the humanizing patina that the Court of Appeal referred to. Is that correct?
Yes, Your Honor.
Has that undermined things in Canada?
But that is the question I'm not well placed to answer.
Well,
As a person resident in Barbados, I've compared the two systems, and I think there's much to recommend the British analysis, because I think the employer retains both procedural protection and his contractual rights.
well, if you have looked at it and you found that the British system is the better one, why didn't you look at the Canadian to see if the Canadian system has undermined things there?
Well, I do find the test in Canada more difficult to understand in practice and to apply. If we're looking at a sliding scale of reasonableness, we have a very different analysis from a traditional contractual approach, which simply looks at whether conduct is repudiatory or not, where we're starting to look at years of service. Does that mean that if I have a nanny for 20 years, she's entitled to breach her contract willfully and be excused for that if I've made a zero tolerance policy, which was the example used in the court below to underline the point. I believe that...
Is it possible that what happened in Canada is that the recognition that employer-employee relationship, or contract as it were, is not the same thing as a contract for supply of machine parts or motor vehicles and all that? This is a contract between human beings in which a lot rights. And contract perhaps textured by human rights standards that tell us that people have a right to work. And I believe that Barbados is party to the UN Covenant on Economic, Social and Cultural Rights, where that right is declared, party to what happens at ILO and all that. These are things systems need to take into account in modernizing their employment law, moving it away from what was the case in the 19th century. Is that a way to look at it?
I agree. And the question always remains, how do we rationalize that interest as we do for other forms of contracts, we do the same thing, for example, with landlord and tenant, etc. There are many legal relationships which the legislature and indeed the judiciary have considered it necessary to impose terms, implied terms, etc. But because of that commercial necessity, I think there's much to recommend the traditional contractual analysis, simply in terms of certainty. And I think if we're going to depart from that, we ought to have a rational, objective basis for so doing. Because both employers and employees afterwards, which is what I'm hoping will result from the ultimate decision of this court, must understand how they are to relate to each other. So if we have formed a contract such that if you breach this term, you will be dismissed, and you breach that term, is there some overarching principle that undermines that result that we both agreed to at the time of forming the contract?
I don't know whether you're in a position to answer this, but I believe the International Labour Organization, the ILO, has this recommendation 166 of 1982. I call it a recommendation because it is not the treaty. There's a treaty of 158, but the recommendation 166 says in the first provision, the first article of the first clause, that the provisions of this recommendation may be applied by national laws or regulations, collective agreements, works rules, arbitration awards, or court decisions, and so on. So works rules, and then it sets out certain standards to being you give an employee written the warning before you sack them and give them time to make corrections to their conduct. Do you know whether your clients had that system in place?
It appears that at that time some form of right to be heard was recognized, but it did not seem to have, looking at the handbook that we've produced to your honors, the level of clarity that is required now in order to comply with the Employment Rights Act.
Thank you.
Yeah, Mr. Koyman, I saw that the handbook had a reference to hearing. Just very, very briefly, there was a reference to that. I wondered as I saw the evidence in this case that in fact the respondent was given a hearing, the basis on which that hearing was held. Are you in a position to help us with that?
Not particularly, Your Honor, only because that issue did not appear to have engaged. There was no cross appeal, and it certainly did not form the basis of the appeal before the court below in terms of...
No, I'm not talking about that. I'm talking about what would have been the basis for your client giving Mr. Forde a hearing.
I believe
ordinary, as far as you are aware.
I believe ordinary industrial relations practice as opposed to a contractual obligation.
I see. So the handbook at the time did not impact on that as far as you're aware?
I recall the handbook imposing a right of appeal, but I don't recall the handbook mandating, craving the court's indulgence, a hearing as such before dismissal could occur.
But it does speak about it. I just wondered whether you had instructions as to how that operated in this matter.
I do not, Your Honor. Other than a reference to progressive discipline, the fact that warnings ought to be imposed at first instance for less than serious offenses, and it does go on both for disciplinary and ordinary grievances to provide for a right of appeal, but I don't recall seeing anything in it specifically speaking to any procedural right to a hearing before discipline could be imposed per se. So that it would appear that as a matter of contract, the appellant was entitled to proceed as it did. Even to proceed more drastically than it did, in that there would have been nothing precluding them from dismissing without having offered the respondent the right to be heard.
Yeah, so you refer to good industrial relations practice then?
Yes,
That,
yes, Your Honor.
that is probably the basis of it. And where would those good industrial relation practices be found?
There's some reference to them in the same ILO conventions that His Honor referred to a while ago. And the appellant does have a devoted human resources department, which would, of course, have been trained in industrial relations, etc. So, and it suggests that there's a commercial basis as well for the introduction of these principles in terms of ensuring a properly working workforce who feels
Mr. Coleman,
duly heard.
let me ask you, if I may ask you something just on that, so that if you want to base this in contract, but then you have a contract and you produce a handbook, what is the status of that handbook in terms of the contractual relationship? If you have a contract, employer-employee, and in this case you want to rely on your common law right in contract to summary dismiss, no problem. But you've created a handbook that does that form part? Is there a good faith expectation that part of what this contract includes is that what is in the handbook on both sides, on all sides, would be considered?
I believe so, Your Honor.
Right.
The reason why
Right.
we often try to ensure that policies aren't contractual is so that they can be changed unilaterally. But I think it's reasonable for an employee to expect.
Until they are changed, is it not reasonable for both parties as part of their contract to consider this, as I say, a good faith expectation? So your page 22 outline of discipline and disciplinary action is something that the parties, I assume, have agreed to, or certainly if it's produced by the employer, it's represented as part of what this relationship is governed by. Because you see, one of the questions in this appeal, I know you've said in a certain way, this question of process doesn't apply, but the adequacy of the investigation, it can be looked at in a very narrow sense of one side doing an investigation, but the adequacy of an investigation can include a process that allows a party to be, for example, confronted with the issue, etc., etc. So that,
Yes,
yeah, would you accept that in this particular case, given your handbook, that is to be construed as part of the contract?
So to answer both questions, yes, I believe that the parties would have had an implied obligation to comply with the handbook, notwithstanding that the handbook itself could be unilaterally changed as a matter of policy. And I'm saying that in this case, it was followed. So the handbook makes reference to disciplinary hearings, a right to be heard if the employee is a member of a bargaining unit by a union representative. And consistent with that, there was a hearing, and that the parties could have gone on to have a more detailed provision in terms of the process to be followed if they so felt. And if they fail to do so, then the employer would be in breach of contract. And there's a line of cases dealing with that. Some were considered in the Cato decision that my learned friends referenced in their submissions. But that issue doesn't really arise here insofar as there's no question of the appellants not following their process. The question is whether, having followed their process, they were right to proceed to dismiss without notice.
Madam President, I don't know whether Mr. Quayman has more time, because I need to ask a question about the letter of termination. that appears at page 1037. Can I?
Certainly, yes, certainly, my brother.
Right. Mr. Koyman, can you please go to your letter, your client's letter of termination? I think court record page 1037, that is 1037.
Attempting to retrieve it.
Are you there?
Not as yet, Your Honor.
All right.
System is impeding my efforts to
Well,
backwards.
while you're looking, maybe I should register my question. My question is, looking at that document, what exactly does it tell us that the employee has done?
Grateful for the court's indulgence. I have it at last.
All right.
It
Tell me
refers
if
to
I could-
substandard work performance and a failure to comply with and enforce the company's rules, regulations, policies, and procedures, leading to a loss of confidence in the ability to effectively perform his duties.
Should there not be any particulars to that? Specific? I'll tell you why that question matters to me. Because this is like a pro forma that other uses pro forma language that you lift out of rules book, but doesn't quite say what exactly the person did to which those descriptions attach. The problem with that might be that when something is couched in this manner, you may have a scenario where in the course of a court process, somebody may incriminate themselves, may say things that, by the way, all sorts of other stuff add up to what we were talking about. So suddenly you're now having a retrospective look at what somebody did, so that things that may not have operated in the mind of the employer at the time of termination can now retroactively start coming in as considerations to take into account when a court decides whether employment termination was wrongful or not. That's one concern I have. Can you please address me that I was wrong in that view?
Well, as delicately as I can, my position is that the critical import of this letter was to communicate to the respondent that his contract of employment was at an end. And the question then becomes for wrongful dismissal, whether at that point there was a basis for summary dismissal, whether on grounds contained in that letter or otherwise. And it is that which the court considers. And that is one of the main reasons why I resist, if I can use that word, the humanizing patina, because it focuses attention on what the employer knew and did prior to dismissal, as opposed to the question whether just cause existed or not.
Thank you.
so that the
Mr.
context of the
Koyman?
letter.
Sorry.
Yes, Your Honor. I
Mr.
beg your pardon.
Koyman, you have invited the court, as my colleagues have said, to provide some clarifications with respect to the law governing summary dismissal. And I wanted to draw your attention to paragraph 24 of the appellant submissions, paragraph 24, where I think you do set out, after you have reviewed the authorities, what you discern the appropriate question to be. And this is after referring to the humanizing patina that you have expressed concerns about. You've said it's submitted that properly understood, the authorities do no more than establish the, quote, logically high threshold that conduct must usually reach before it may be considered repudiatory and so establish just cause for dismissal. Now, the Court of Appeal's inquiry was focused on whether the conduct of the employee was
Is it just me? I think Justice
I've also
Onondo
lost-
is frozen.
I lost her as well.
I think
Yeah.
we all have. Okay.
In fact, she will have to go out and come back in. Mrs. Thomas Roberts, is there any assistance that
I
IT
will-
can give her?
Yes, Judge. and
Can
I
you
may
reach
try-
out to her?
Yeah, I
Thank
may
you
try
very
calling her
much.
because I think she's in the court. Thank you,
Okay.
Judge.
Thank you.
Yes,
so
thank you.
much. If she is in the court, that should make it very easy for us to assist her.
In the
Counsel,
meantime,
I
Mr.
hope-
Quimman
yes.
can start, give us some other aspects of his submissions while we wait for Jacinda would come.
Uh,
But
What if it is appropriate for me to do so in her absence? I would say
I
that
would prefer if you just held on a few minutes.
I think so.
Mr.
I stand
Yes,
corrected.
Mr. Coleman.
Madam
Yes,
President.
thank you. That's all right. Thank you.
Mr. George, we
Yes.
may have to just take a short break for a minute, please. I'm trying to get onto her. AOJ is not there and someone else is helping me, all right? And we're also trying to get in contact with IS.
Would you suggest, and I think we could just stay online as we are?
Yes,
Yes?
you
Okay.
yes, you
Thank
can.
you.
Yes, Madam Justice.
Yes,
George.
yes.
Thank you.
Thank you for your patience, Counsel.
certainly.
Thank you.
She's next door to me. Let me pop over and see.
No, Judge, she says she's automatically restarting. So
Oh, right. Okay.
yeah,
Fair
she's
enough.
just yes. So
We would not want you to add to the trouble, my brother.
Fair enough.
Chair, I am back on and my computer automatically restarted on me. I was so engrossed in the hearing, I didn't see a notice coming up that it was automatically restarting with a countdown. So if I could return to my question?
Yes, please.
Thank you so much for your
Thank you, and
patience.
welcome back. Yes.
Thank you. Mr. Koyman, before the interruption, I had drawn your attention to paragraph 24 of the appellant submissions, where you had set out, based on your review of the authorities, what the logical inquiry of the court should be. Whether the conduct of the employee is of, meets the requisite threshold to be considered repudiatory and so establish just cause for dismissal. The Court of Appeal's inquiry, as I read it, would have been whether the employee's misconduct was such that it justified a summary dismissal. Could you elaborate what you see the material difference between the two inquiries to be? On the one hand, inquiring into whether the conduct of the employee is of such a high threshold, it's so serious that it thereby constitutes a repudiatory breach of the contract and establishes just cause for dismissal on the one hand, and the Court of Appeals inquiry, which was fundamentally whether the employee's misconduct justified summary dismissal. What do you understand to be the material difference between the two inquiries? Thank you.
Pledge for the question. The Court of Appeal, as I understand it, is applying a broader-based approach to the question than the contract itself or contractual analysis would merit, taking into account considerations such as length of service, length of service being a particularly impactful one, to determine whether it was right to treat what was clearly misconduct as rising to the level of not just justifying dismissal, but dismissal without notice, which is distinct from the common law test, which solely focuses on whether or not the conduct itself is repudiatory. And why I think that dilutes the test is that however long an employee has served, whether or not they were entitled to a fair hearing and all of the other reasons, would not affect that fundamental question, whether the conduct itself, taken in the context of the contract between the parties, was repudiatory or not. The impact of warnings, basically all of the procedural understandings of wrongful dismissal and the law of employment are geared towards the question whether an employee is sufficiently apprised of the importance to the employer of a certain pattern of a certain code of behavior, so that lateness, for example, would not, in most cases, automatically be considered repudiatory. It must be that the employer brought it home to the employee either by a set zero tolerance policy or a series of warnings, making it clear if you are late in the context of this business, that is serious enough to me, the employer, that I would dismiss you as a consequence. And the court, at first instance, recognized that it is the employer to make that determination. Commerce is determined on that basis. I determine my need for labor and I set what duties I wish my employees to perform and subject to what parameters. And I determine what is so fundamental that it cannot be departed from, and if it is, I will dismiss. What I consider to be the danger of the Court of Appeals approach is that it removes some of that organizational power from the employer and imports wider questions in terms of how reasonable the decision is and arguably how reasonable the policy is, because it is from the time the magistrate accepted that there was a zero tolerance policy for removing items from the back door without proper clearance. In my view, that necessarily means that that's the line the employer drew, and any other determination would fundamentally append the right of the employer to determine how his or its business ought to be conducted.
So, Mr. Koyman, just a hypothetical quickly on that. So that if the employer decided in its policy that coming late was a basis for, in its policy, sufficiently egregious for dismissal, would your principles still apply? I.e., no inquiry into the reasonableness? So suppose an employer set that as one of its standards.
I don't think that's necessarily unreasonable. So if the business is, for example, a train station, it would be fundamentally important for the driver to be
Well, I'm trying to create a hypothetical where it is not.
Yes.
In other words, if you put the power completely in the employer, and the employer puts as a standard, which is not integral to function, as a standard for summary dismissal, how would that change anything? In other words, it is open, it's the policy, it's declared, everybody knows, but it is not fundamental to function.
So fundamental to function is a different question from important to the employer. And that's why the question of whether this is to be part of the contract or not, law of contracts or not, is so important. Because it's up to the parties to decide whatever. We're not slaves.
So that your answer is whatever the employer deems important to the employer, whether or not it is fundamental to the contract, for you, that would be a sufficient basis for summary dismissal, if there's a breach of it.
I say yes, because it is a question of breach of the contract. So the parties
Fair
determine
enough.
what are
Fair
fundamental terms.
So that the employer says, if you have a bed, if you wear a hat, if you wear a short sleeve shirt, doesn't matter. It's important to them. They state it. It's in the contract. We all know summary dismissal.
So
On contract.
yes,
Yes. Good.
yes,
Yeah.
which is what wrongful dismissal is concerned with. Only contract.
If I may
It's
add to
not what
that,
the parties agreed.
if I may add to that example, we have zero tolerance policy for removal of goods without authorization. You do that, you lose your job. And the employee removes rotten fish from the supermarket. That is a breach of that term. So according to your analysis, that justifies immediate termination.
The answer to that question is determined by how clear it was to the employee that that was the policy. So we could
let's say simply, let's go back. It's about zero tolerance. You will not, no employee must remove anything from the shop, from the supermarket without authorization. That's clear.
yes.
What was removed by the employee was rotten fish to be thrown away. According to you, that is a breach of the contract. Therefore, termination is warranted, immediate.
But there are two ways to interpret Your Honor's question. The first is a question of interpretation. So if the employer used the words anything, the question would be whether rotten fish is contained in anything or not. And the court reviewing that question in the case of wrongful dismissal would be applying the standard of the ordinary person. And I think the employer would be hard pressed to explain that in the context of that contract, it would have been clear to the ordinary man and should have been clear to the employee that it included rotten fish. But if the employer had specifically included rotten fish and the employee willfully disregarded that principle for whatever reason, the parties had knowingly agreed to that, then that would be a breach of contract because it would be contrary to the bargain between them. And if it was willful, it would amount to it would not give rise to wrongful dismissal. The employee or the employer would be justified in dismissing. So that's why you want it to be clear.
Your example takes us to the higher, you're moving it down to the lower level of abstraction. Let's take it to the higher one, which is you do not remove things. I believe that would have been what the evidence in this case reveals. They did not say you must not remove condemned rights. They do not remove things, and the bag of condemned rights was removed and the employee terminated. So let's leave it at the level of, because I'm still inquiring, I'm interested in Justice, my brother Justice Jamada's inquiry there. Is there room for reasonableness in that whole inquiry? If we are moving that inquiry in the territory of repudiatory contract, violation of contract, does anything amount to repudiatory, any violation amount to repudiatory violation, or do we need to inquire into how fundamental was that breach in the particular circumstances before we can characterize it as repudiatory?
And
And before you answer
Mr.
that question,
Koyman,
Counsel,
I'm
you may
sorry,
also-
Justice Barrow.
Sorry.
Mr. Koyman, before you answer that, just bear in mind that time is running out on you. We have asked you questions, I think, almost for the last hour. So we will give you a few minutes to wrap up your important submissions. We have your written submissions, so you can be assured that we have read those. And Justice Barra, if you could allow Mr. Koyman to give us those, and then as we wrap up, you can ask your question.
I see. So the question from Dr. Ibo Osuji is also off. Okay.
No. I'll let him answer that, and then he will wrap
But I
up.
thought I was adding to that question.
Oh, please go ahead then.
Yes. In answering that question, Counsel, would it not be a part of your consideration the policy as opposed to the item or the objects being removed? In other words, the employer has a policy to stop stealing, to stop pilfering. I want nothing removed through the back door because it is not for me to monitor the identity of the things being removed, whether they are rotten fish or things masking as rotten fish. Would it not be really a question of policy, Counsel? That's it. The rider I would add to my brother's question.
So in my view, the overarching principle there to be applied by the court in answering the question whether in the context of that policy there was cause for dismissal or not is not reasonableness, but contractual fairness or clarity. What would the rule mean to the ordinary person? It appears to have been accepted in this case that the property removed satisfied the de minimis principle. And it is really a question of a breach of the rule that, though it was a breach, did not cause economic harm to the organization, etc., and so could be considered less serious in the context of the respondent's long service, the fact that he had received commendation, etc. And I'm saying that the question is simply one of willfulness and clarity. If he was aware of the rule, was aware of the consequences of breaching the rule and knowingly breached the rule, in my view, that is classical cause for dismissal for failure to follow the lawful orders of the employer, and that any other result would be entirely inconsistent with, I believe, the general understanding of employment law, where the fundamental obligation of the employee is to obey lawful orders.
Yes, Mr. Koyman, we have your point, and you may wrap up now.
I welcomed the approach of the panel in terms of questions because, as Your Honor pointed out, the submissions are there. I hope I was clear enough that my points are well understood. So I wanted the opportunity, to the extent that the implications of what I have said could be explored, etc., and placed into their proper context, that I would have that opportunity by being posed questions. And I think most of the points that I wanted to make, I was able to make in responding to the questions of Your Honors. The only one that wasn't addressed, I think, to any extent would have been the matter of condemnation, which was raised by the magistrate and the Court of Appeal below, accepted that it was found by the magistrate, but they appear to have considered it, I can only assume based on the result, not central to the decision of the magistrate. But in my view, to the extent that the magistrate clearly expressed it to be a material consideration for him, and having found that, in his words, the conduct of the appellant was breach to the respondent was breach of a zero tolerance policy that should have attracted strict censure, it appears that he was materially influenced by a consideration of whether there was condemnation in the case. So that I consider that the result is unsafe if the Court of Appeal agrees that there was in fact no condemnation by virtue of other breaches not having led to dismissal.
Madam President.
Chair, could I just ask one final question from me, just for clarification?
Yes,
Mr. Koyman, I have noted that there has been a consistent characterization of the company's policy regarding removal of items as a zero tolerance policy. Could you clarify what's the basis for this? The reason I'm asking is I am aware in the evidence that there was a sign that was displayed concerning removal of items. It said, please do not remove items from this area. Any person caught removing items from this table without authorization will face, quote, disciplinary action. It says disciplinary action, which is not quite necessarily the same as instant dismissal or dismissal without compensation or notice.
Yes, so in this matter, we do.
Yeah, if you could just address that, just for my clarity, thank you.
We do not have, unfortunately, the benefit of a transcript or even detailed notes of evidence, but we have the magistrate's decision in terms of the findings that he made. And the finding that there was a zero tolerance policy was his. So that is found at paragraph of the magistrate's decision, proving the court's indulgence. Fortunately, I won't have the page number for the record, but it is paragraph.
May I assist the court? May I assist my learned friend?
Please do.
Thank you. Page 600 of the Record of Appeal, paragraph 34.
Yes, under the heading single act of willful misconduct. It was there that in our review, having found that the misconduct reached that level and that the policy had that extent of clarity in terms of the sanction attached, that it must be, if the magistrate made that finding, that he should make the correspondent finding that there was cause for dismissal.
Sorry, Counsel, could you read the sentence in which zero tolerance appears? I have a recollection. I don't have it before me. The magistrate said something along the lines that it was accepted by both sides. Tell me what it says.
It is accepted that the plaintiff, as backdoor receiving supervisor, was a long-standing employee and thereto ought to have been well aware that the company had a zero tolerance policy. A zero tolerance in respect of non-saleable dumped items.
Thank you.
I don't know, just Honorable, are you still asking? All right, fair enough. Mr. Koyman, could you kind of clarify for me what you're saying? And you may have said it in relation to your last point on condonation, but I want to be clear to understand what you're saying in your written submissions in ground B. That would be paragraph 11 of your submission, ground B, appeal record, page 733. The last part is what I'm particularly interested in, but it says here, are you there?
Yes.
All right. That the magistrate's decision was against the weight of the evidence, as in making his decision, he relied upon the finding that there was condemnation by the appellant. But I'm interested in this part. Mr. Koyman says, but the evidence related to other breaches of policy and not the policy in question, so that there was no evidence of condemnation. Can you explain to me what you're saying there, please? briefly.
So it is common ground between the parties that prior to the incident that led to the respondent's dismissal, there had been breaches of other policies which were dealt with by verbal warnings.
But not breach of the zero
Not breach of
tolerance
this policy, yes.
of removing condemned items.
That is
So there was no prior citation of this employee for violation in that regard.
of this policy. That is
Thank
correct.
you. Thank you very much.
And therefore the finding of condemnation was not made up.
Thank you.
Yes. Thank you, Mr. Coleman. Are there any other questions from the bench? If not, Mr. Coleman, that brings an end to what you wish to submit this morning.
I believe so, Your Honor. I'm
Thank
much
you very
obliged.
much. Yes. Mr. Khan, we're ready for you.
Thank you, Your Honours. Am I allowed to, before I address my submissions, make some observations?
Certainly, if they are matters arising from today.
Thank you very much. Can I take this honourable court to page 18 of the record of appeal, which is paragraph 45 of the Court of Appeal decision. And if I can just read this into the record, and I understand that Your Honour, Justice Onowu, made this issue, but I do want to dwell on it if I'm permitted to do so. And this is, let me read it first. The management's evidence also relieved that there was a prominent sign reading, "Please do not remove items from this area. Any person caught removing items from this table without authorization will face disciplinary action by order of management." My observation is this, Your Honours. This has become termed the zero tolerance policy, and yet, notwithstanding that I wasn't involved with this at first instance at the Magistrates Court, I am hard put, Your Honours, to understand what the end objective of the zero tolerance policy is, because as I read it, it doesn't say emphatically that you will be sacked, you will be dismissed. It says that you will face disciplinary action. So I do not want to reinvent the appeal, and this is something that I've been remiss of, which I ought to have raised at the Court of Appeal. But all of this has sprung as a result of the inquiry by this honourable court regarding the termination letter. And I say all of this, Your Honours, because there is no definitive statement before this court that the zero tolerance policy would lead to automatic summary dismissal. Now, whether this honourable court accepts that or not, that's my reading of the evidence and the decision of the Court of Appeal below. Secondly, the other observation I make is this. The 21st of December 2012 letter, which is page 1037 of 1039 of the Record of Appeal, this is the letter of termination. And again, Your Honours, probed into this letter of termination. And I make the following submissions. It is my submission that this is a template, that this has been lifted, and it's one size fits all. It is non-specific. It is as broad as throwing a net in the ocean to catch anything that comes into that net. This incident occurred despite verbal warnings regarding inter alia. Disjointed, disconnected, disassociated events have been morphed into a letter of termination without any substance, without any explanation, without any context. I would submit that to be disturbing, because at the end of the day, it does not say that because you breached the zero tolerance policy, we have decided to sack you. It simply throws a number of things together. Now, I add this. One of the inquiries from this honourable court was whether there was a record of any of the verbal warnings, and there are none. The appellant hasn't been able to produce them. That is significant because to cite an accumulation of warnings, as his letter does, and then not to be able to evidence them, I say is a fundamental flaw. Let me then go to the employee handbook, which was submitted into evidence. And if I can just crave your indulgence.
Counsel, before you go further, help me here.
Yes.
Was there any doubt at the time of the dismissal, at the time of the giving of that letter, that the employee was being dismissed because of the removal of the things through the back door? Was there any doubt?
As I said, I wasn't there at the time that the dismissal occurred, but I have no reason to believe or to say otherwise that this issue of dismissal arose because of the taking of the non-saleable condemned rights. So I don't think that in itself is the issue of doubt. However, I take issue with the letter citing what I believe to be an incremental policy leading to the dismissal.
Mr. Khan, for myself, I thought that the employer was being quite decent and restrained in not putting into the letter a statement such as, because of this incident of, and characterizing it as dishonesty or whatever. I thought that this was a fair and kind way of phrasing it, but I may be wrong. And if I am misleading myself, do correct me.
I think that you're entitled to that interpretation, Your Honour. My interpretation, if you wish to accept it, is that they had nothing. And they, in my view, they put together an edifice of a case, cited what they believed to be existing warnings to bolster and boilerplate their termination and dismissal of the respondent.
I quite understand you, thanks.
Thank you.
Mr. Khan, before you move on to the employee handbook, you said there was no evidence of warnings, but for my clarification, was it admitted in cross-examinations that there were warnings, albeit for different, maybe for different infringements? That's the impression I have from the record. But you say there was no evidence of warnings. Right. Can you assist?
Yes, no, there was definitely an admission that warnings had been given. I was very careful to say that there were no records of any verbal warnings that was able to rely on.
Okay, thanks.
That was the, and I guess that is a narrow point, but nonetheless, I wanted to make that point. If I may I take you to page 1052 of 1061, which is the employee handbook. And this is actually page 22 of the handbook, which I believe Your Honours raised earlier on. I want to sort of reconcile this with Justice Asujo, Your Honour, Justice Asujo, I hope I'm pronouncing it properly, direction to recommendation 166 of 1982, if I can proceed on that basis. And I quickly Googled that. Google is my reference in case I am absolutely wrong, but I'm going to read the extract. The employment of a worker, and this is from 1982, should not be terminated for misconduct of a kind that under national law or practice would justify termination only if repeated on one or more occasions, unless the employer has given the worker appropriate written warning. Again, I know that one size does not fit all, but it is my submission that there is a degree of modeling in the extract that I want to read from of the employee handbook, and that's the discipline and disciplinary action. It seems to me that the appellant adopted an incremental approach to disciplining, regulating, and modifying the conduct of its employees. And it says from the second sentence onward, in confronting the issue, management will give the guilty party a verbal warning. If the problem recurs, the employee will be given a written warning, a copy of which will be placed on their file. Depending on the circumstances, failure to improve will result in the issue of a second written warning. That is important. I appreciate why the court, through its registry, asked for sight of this, because I think, and I would submit, that this is the basis that the Court of Appeal adopted the contextual approach. And I've said in my submissions that once an employer sets itself up with a process and a procedure of disciplinary incremental action, it exposes itself and it makes itself amenable to the doctrine of fairness, procedural fairness. This is significant in my submission, Your Honours, because it seems to me that there was leapfrogging straight to summary dismissal without any of the incremental steps in between. And moreover, the issue of the taking of the rice, which the Court of Appeal dealt with at length.
Mr. Khan, I do not wish to interrupt that flow. You are getting to the taking of the bag of rice. But let me take you back to the employee handbook you mentioned. When was this implemented? Do you know? Do we know? So I looked for a date on it. I couldn't find it.
From the representations of the of my learned friends, this was the handbook that was available and given to the employees at the material time of the dismissal. Now, my learned friend will correct me, but this is my understanding of the currency of this particular handbook. It was the one issued to the respondent because prior to Massy taking over, Supercenter was owned by BS&T, and this is a BS&T employee handbook, which was in operation at the material time.
When was the takeover?
I have here, oh, sorry, remember the takeover. The takeover was, Your Honours, I believe, and I may be wrong, sometime in 2014, 2015, I may be wrong.
Thank you.
Right. Sorry. Can I continue with my? Thank you. I know I've said a lot in my submissions, and I'm conscious that this court will have read them and will question me on them. But I do want to take this.
Mr. Khan, are you moving away from the handbook? Are you going to move off the handbook now?
Well, what I wanted to do was to juxtapose this with an extract from the magistrate's decision.
Right, so just before you do that, just for the maybe coherence in the record, because you're on page 22 of the handbook.
Yes.
I think Mr. Koinman accepted that the handbook would form part of the contractual relationship between the parties. So that much I think is accepted. Now, when you read the I'm sorry.
Sorry.
When you read the same paragraph, discipline and disciplinary action, in confronting the same line, in confronting the issue, management will give the guilty party a verbal warning. Now it says they will give the guilty party a verbal warning. I just want to highlight that for a moment because that assumes a finding of guilt. Then at the last paragraph, employees who are also members of a bargaining unit will have a right to union representation in disciplinary meetings and hearings. So when I put those together and I'm asking a question, it raises a question in my mind that even though it may not be as clear, there is clearly the anticipation of a hearing before a finding of guilt. Do you accept that that is so from the text on page 22?
I do. I do agree with that. I agree that, and that's why I chose the sort of term incremental, that the logical outcome of this is to a full-blown hearing.
Right. So that the stage of warning before dismissal, there is maybe built in a prior stage, which is a hearing and determination of quote unquote guilt. And then it suggests, if that is arrived at, a warning. And then if there is non-compliance with a warning, it says what happens, maybe culminating in dismissal. Would you say that within the context of the handbook, that is a reasonable process that one can discover and expect that employee would have a reasonable expectation according to their contractual arrangement that this would be the process to be followed?
I do. And can I just perhaps nuance this a little bit, if I may, Your Honour? I think that the hearing being held is not simply exclusive to the most egregious of offences. I think it is available for any offence that a person is alleged of. And the outcome could be a verbal warning as a result of a hearing. It could be a written warning, a final warning. But the hearing itself is not indicative that this is it. This is the final chance before we get rid of you. I think it is available to all infractions. So
well, it says that, right? It says any improper conduct consistent with poor performance, etc., etc.
Yes.
So,
yes.
And when you look at the letter of termination, and if you read those together, it would suggest that if we were to come to the conclusions in the letter of termination, it could have been inclusive of this. Now, having said all of that, I want to ask you a question of law, because I think Mr. Koinman may be making a distinction between this. Is it that as a matter of law, the argument of your friend, as you understand it, is this: where there is wrongful, where there is dismissal, summary dismissal for just cause, that at common law, this process can be circumvented?
My answer to that, Your Honours, is this. I believe that the common law, I submit, is a dynamic creature. It evolves, it mimics, and it borrows. And in its development, it will borrow from statute, it will borrow from practice. As to my limited understanding, as the law is developed, so has the concept of procedural fairness. I don't think, and I would submit, that no employer has the right simply to dismiss as a matter of course, particularly where they make available a process of disciplinary hearings. They, in my submission, impute and inculcate the very principles of procedural fairness. It has to be built in.
Sorry.
So, no, you go ahead, Dennis.
Yeah.
I have something to follow up, but you go ahead.
Counsel, in relation to the handbook, I was curious as to this multi-stage step which must be taken in relation to discipline, because it seems to me that if an employer, for instance, and this is purely hypothetical, catches an employee stealing a most valuable item from the premises, that should result, or would not naturally result, in instant dismissal. So I went back to the handbook, and I see, and it relieved my sense of what is good sense.
Mm-hmm.
At page 21 of the handbook, the introductory words, under standards of conduct, the second paragraph under standards of conduct. While no attempt has been made to provide an exhaustive list, we have outlined several of the most obvious actions that are not permitted while at work or on the company's property. These include, etc. So, for instance, you will see that stealing, for instance, is not included in the list. Yeah? So I just want to say to you that my sense of it is that that step which follows on the following page, the warning, approach, etc., a second chance, and so on, those are with respect of limited application, aren't they?
In answer to your question, my Honor, those steps are available to all manner of incident and action. But of course, nothing is static. So it is fact sensitive. If this is somebody fighting in broad daylight and they brought the shop into disrepute, there are a couple of employees, I think it's very clear cut. Indeed, my learned friend has cited the case of Southern Meats as one of his authorities, which really does speak to that type of incident leading to no other conclusion than summary dismissal. So yes, employers have a degree of maneuverability within their own disciplinary procedure. Absolutely right. Can I just make the point, though, that the respondent is not accused of stealing? His general manager stated he wasn't stealing. The magistrate made a finding that he wasn't stealing. It is regrettable that my learned friend, learned counsel, opened up his submissions on the context of theft when that isn't the issue at all before this honorable court. It is one of whether the taking of condemned pet rice could justify the employer in summarily dismissing.
Mr. Khan, is it therefore your submission that it is not open to this court to say that what took place was stealing or came pretty close to stealing because, for instance, the manager did not report it to the police, the manager did not regard it as stealing? In other words, the quality, the objective quality of what was done, are we confined in our determination in assessing that objective quality by the stance taken by the general manager who may or may not have known what stealing is?
Okay. Like the Court of Appeal below, and within the jurisdiction of the Caribbean Court of Justice, you are a review tribunal. However, that doesn't mean that even where there's a finding of fact, you're not disallowed from putting yourself on an inquiry if you find that that fact and the finding of that fact was patently wrong. It is my submission that that finding of fact was not patently wrong. Now, you may dismiss my submission, but that is my view on the finding of fact by the magistrate at first instance.
Again, counsel, I have you very clear on the matter.
Okay, thank you.
Yeah. Mr. Khan, before you leave the handbook on page 22,
Yes, you are.
the last sentence of that very first paragraph, it says for the most serious offenses, management may dismiss the employee for the first occurrence. So the impression that I get reading this is that there may be, as I think you mentioned, fighting, hand in the tilly, in the till, sort of serious offenses. They say for the first occurrence, they may.
Yes,
So they reserve the right to dismiss.
they do.
And yet there seems to be in that sentence, for me anyway, a discretion to be exercised, but a discretion to be exercised in all the circumstances of the case. And that is how I thought that I saw the employer itself importing this humanizing patina Perhaps I have looked at it in the wrong way, but I thought to hear your thoughts on it by way of clarification.
If I have you correct, Your Honor, are you putting to me that in the construction of this handbook, the employer imported a humanizing patina?
Yes, or imported at least the contextual approach. It says, look, we will look at everything
Yes.
that has happened in this case before we come to a conclusion that you will be dismissed.
I agree with you, Your Honor. And when my opening salvo was that I took the opportunity to exploit the reference made by His Honor Asuji, and I read in the recommendation of the ILO, and it was my initial submission that this is modeled to a large extent on an incremental, fair standard, and open and transparent process. So yes, it is, in my view, if applied correctly and with reasonableness, it ought to do the job. But that's how I read that objectively.
Chair, may I ask for the reference that you made for the most serious offense? Where is it?
It's at the under discipline and disciplinary action, that rubric, and
Page
it's
what?
the last page 22, and it's the
22.
last sentence of
Thank
the
you.
first paragraph. You're welcome.
Appreciated.
Yes, you may go. You may proceed, Mr. Khan.
I think that His Honor had a question for me, Justice Asuju.
No, I do not. Sorry.
All right. I think that Justice Jamdar was to come back to me on something before I carry on.
Yeah, no, I just wanted to, you see, where we've reached in our conversation with you anyway is looking at 22, and the premise for page 22 of the handbook, the premise for that is that it is all part of the contract, or the expectation of the contract. And where we've reached is that even in the relation to may dismiss, there is a step within that of an opportunity to be heard. So we've kind of crossed that now. But what I wanted to ask you is to put to you, to juxtapose that process with the common law position. So this is a case about a wrongful dismissal. And if the employer dismisses without notice, they are guilty of a breach of contract, unless at the time of dismissal, the employee was guilty of a fundamental breach of contract. So that's the principle. That's the repudiatory breach, right? And that's where, if you have just cause to dismiss, you can dismiss. So I only want you, so the kind of argument is the only consideration is just cause. I can dismiss summarily, and if you challenge me and say that was wrongful dismissal, if you challenge me and say that, once I can show just cause at common law, then, you know, the employer is, as they say, home and hosed, right? Good. Our sort of inquiry has been around this just cause and the objectivity of it, and the idea of reasonableness. That's one aspect. And then the other aspect, more procedural, is whether or not there is a sort of a fair hearing process that must be part of this conclusion of just cause. Yeah? Yes. So my question to you then is, given that historical common law position, which your friend subscribes to, how do you reconcile that with what we've just said about the contract and page 22, etc. of the handbook as part of the contractual relationship between these parties? What's your response to that?
In my submission to you, if I'm crude in my rendition of the decision in your decision in Cato, Sandy Lane, this honourable court talked about the development or the implied duty of trust and confidence and how that's developed and evolved over the decades. And the expectation that an employee who has been brought in on a contract of employment with a particular process built in, such as a handbook, such as a disciplinary procedure, it is not unreasonable for that employee to expect their employer to treat with any disciplinary issue in a procedurally fair and open manner. Now, if that's a long-winded answer, I'm trying to capture both the conceptual issue and the practical issue of the relationship between the employer and employee. But that's my understanding, Your Honour.
All right. So thank you very much.
May I continue?
Yes, please.
Thank you, thank you, thank you. I've already made the submission to Your Honours that I would ask you to caution yourselves from treating this as one of theft, for the reasons that have been set out before, Your Honours. And I would like to read a couple of paragraphs of the Court of Appeal decision. Now, if I'm going off script, I go off script because I'm confident that you're aware of the respondent's argument. But I think it's important that I bring this honourable court's attention to the approach of the Court of Appeal below. And I would wish to take you to page 28 of 58 of the Record of Appeal. This is the Court of Appeal decision. And
What paragraph are you said you're at, Mr.
I'm going to paragraph 77, Your Honour.
Thank you.
And this is the issue that my learned friend, learned counsel, describes as a humanizing patina. I think that is a lovely adjective. And I want to say that it derives from this paragraph. The contextual approach advanced by the magistrate in reliance on McKinley and BC Tell and supported by counsel for the respondent, we understand to create a scenario whereby an employee's misconduct, though it merits dismissal, may not, owing to the presence of other relevant considerations, justify a summary dismissal. This court goes on. This approach we described as a humanizing patina, and I'll just skip the reference, appears to be consistent with Barbadian dismissal law. In Allen and Marriott's, the 4 appellants had been summarily dismissed from their jobs at the respondent's hotel after a consultant's adverse report on the operations of the hotel. Their action for wrongful dismissal was initially dismissed by the magistrate, but their subsequent appeals were allowed. The judgment of the court opined. The court is unable to say that the circumstances warranted immediate dismissal, particularly when regard is had to the long service and the previous unblemished record of the appellants, 30, 15, 13, and 19 years respectively. Now, I have addressed this in my submissions. I've talked about the fact that both the magistrate and the Court of Appeal have honed in on one single willful act of disobedience, and whether that was enough grist to the mill of dismissal. And they found no, because once they put themselves on this inquiry, it is my submission that they have to balance that allegation with the other considerations, the contextual approach, the length of service, whether it's unblemished, whether this is a one-off, how egregious it is. And that is why I submit to this honourable court that the approach adopted by the Court of Appeal is not novel. It doesn't create a new species of law. Rather, it develops the law. It focuses the law. it hones the law specifically to each and different set of facts. I again reference my learned friend's reliance on Southern Meats, which is one of his authorities. The same approach was adopted in terms of how they dealt with the hearing, how they dealt with the act itself. These are consistent decisions. The outcomes are different because they're predicated on the event which led to the disciplinary in the first instance. One was fighting, and this was taking of rice, condensed pet rice, which at paragraph 103 of the magistrate's decision would have been dumped anyway. And I can take you to that reference if you wish me to take you there. Can I also take you, while we're at the Court of Appeal decision, to paragraph 90 of the Court of Appeal decision. This is page 34 of 58. And this goes back to one of the issues that my learned friend addressed. And he was quite right to qualify that any investigation could run the risk of an adverse finding. It didn't necessarily prove an adverse finding, but it could run the risk. But I think, again, it is important to look at the way that the Court of Appeal has evolved over the years, over the decades. Naturally, there were judicial attempts to ameliorate the situation. One may be found in C.O. Williams and Dash, where Justice of Appeal Peter Williams recited the dicta of Sir Dennis Williams at common law, where the relationship between the parties is governed by a contract of employment. The employment is under no legal duty to provide a fair hearing to an employee before terminating the contract. However, an employer who fails to conduct an adequate investigation into an allegation of misconduct against an employee may run the risk of not being able to prove that there was just cause for dismissal. That is important. In this instance, the employer has provided a mechanism. So by providing the mechanism, it is accepted, in my view, in my submission, that that mechanism must be framed by procedural fairness. Otherwise, what's the point of providing that mechanism? It's only worth the paper it's written on. And why put that there as part of the contractual bargain between the employer and the employee? It must have some meaning. And this is what I urge this Honourable Court to do, to give meaning to every aspect of that relationship. Yes, there was an infraction, but did that infraction elevate to the point of dismissal after 35 years of unblemished service, recorded in their own documentation of the employer? I submit not. And the Court of Appeal found on that basis that this was inadequate to rise to the level of summary dismissal.
Mr. Khan,
Yes.
we've been invited in this case to consider what clarification this court can give to employers, employees on the way forward in this sort of matters. And your learned friend pointed to, I don't know whether he is too strong to say sharp, difference of directions between the Canadian practice and the English practice. Two questions for you there. First of all, do you accept that even the law in the UK is as different as Mr. Koyman suggests it is in this matter? That's one question. And the second question is, quite apart from Canada or the UK, do you have a sense of what other common law jurisdictions have done or are doing? We know from the judgment of the Court of Appeal, very useful research the Appeal Court has done. We know what goes on in Barbados. So they think that Barbados jurisprudence is standing in the direction of the Canadian approach, and Mr. Koopman says he's not quite sure that's where things should be going. But do we know what happens in other jurisdictions apart from Canada and the UK and Barbados.
Okay. To your first issue, Your Honour, the situation in the United Kingdom, well, actually England and Wales, let me be precise, is governed by a number of different statutory considerations. You have employment appeal tribunals, you have employment tribunals. You still have the creature of wrongful dismissal claims, which find their way in the High Court. And those are judge-made decisions based on the facts. In my view, in my submission, the Court of Appeal and the courts in Barbados have, and I don't use this word in a pejorative way, but they've borrowed certain principles and made them, molded them into principles that apply to common day Barbados parlance and Barbados practice. They've taken the best, in my view, and synthesized them with the statutory requirements that are already in existence. For example, the Severance Payments Act gives courts a guidance as to the type of damages that need to be paid. The common law development, borrowing from other precedents and developing local jurisprudence, and I think that was one of the complaints of Justice of Appeal Cumberbatch, that he wished for more citation of local cases rather than cases externally. I think it's a healthy mix. You cannot be so isolated that you don't look at what's happening in other territories, but you still develop your jurisprudence. And then there are the issues in Jamaica, where Jamaica has a different setup of tribunals. However, they seem, in my opinion, in my submission, to be a combination of both wrongful and unfair dismissal values and procedures. So the very long, laborious answer is yes, this court does borrow, does model, is influenced, but it has a distinct identity compared to other jurisdictions in the way that it's developed the law on wrongful dismissal.
Thank you.
Thank you. I've already addressed the issue of zero tolerance, so I'm not going to go back over that. I do want to, though, if I may, just crave your indulgence, Your Honours. I want to return to something that Your Honours, particularly Asuji, brought up just now, which is this an area that ought to excite, sorry, is this a matter, is this a case that excites the attention of this honourable court, that there is a dramatic issue which requires a legal and jurisprudential determination? My submission is no, there isn't a dramatic issue for this court to be engaged. There's no dichotomy of thinking. I've said in my submissions that this is a case which is, in my view, in my humble submission, modeled precisely on the way the law has developed, particularly from the case of Cato down. Southern Meats, the very decision itself, which is at issue, are hallmarks of a healthy, developing and coherent framework of the way that the law is exacted and implemented when it comes to dealing with wrongful dismissal claims. Now, having said all of that, I want to put my submissions before this honourable court. I hope that this honourable court accepts my submissions in the context of which I've answered its questions. I don't have anything further to add to my submissions, but if there are any questions from any of your honours, I will take those questions. Well, I must take those questions, and I want to deal with them. So my apologies.
Thank you, Mr. Khan. Any further questions from the bench? It appears not, Mr. Khan, so we must thank you for your submissions this morning. Mr. Koyman, you have a short reply for us?
I do, Your Honor.
Yes, please proceed.
First thing very quickly is to explain what we see at the beginning of our submissions with reference to the act that led to the respondent's dismissal, because it has not and has never been part of the appellant's case that there was theft. We were attempting in very neutral terms to summarize in the first paragraphs of the submissions what were the facts that led to this matter. And by saying willfully appropriated, what I intend to convey is that he appropriated it knowingly. It was not an accident. He deliberately breached the policy. I'm not suggesting that there was any dishonesty or theft involved at all. The other thing I wish to mention is that the dichotomy we're asking the court to address is manifest from the authority that we cite, that of Marcus Alkins, which is a decision exhibited to the appeal, to the appellant submissions, and indeed the Casfield-Seeley decision. We raised that decision because this is an example of the court paying, for want of a better term, lip service to the traditional British analysis, but then going on to consider other factors, begging the question to what extent these other factors apply, and therefore requiring this court's intervention to provide clarity to the law. The other point I wish to mention is that there has been no cross appeal from the magistrate's finding that there was a zero tolerance policy, so that questions now as to whether or not such a policy could reasonably have been found on the evidence. We don't have the evidence before us to form a fresh analysis, and that point has never been raised by the respondent before.
Counsel,
Yes.
could there have been a cross appeal on that finding of a fact?
In the Court of Appeal, indeed. If the respondent were of the view that in coming to the right decision, the magistrate made an incorrect finding, it was open to them to appeal it.
I am a bit lost, but you continue without me.
Yeah, Mr. Koyman, does the zero tolerance policy find landing in the handbook? Does it find
No.
its way into the handbook?
No, Your Honor. So that this is a finding of the magistrate himself from which there has been no appeal. That's what we're trying to say.
Yes, you go ahead.
Your Honor addressed the question of the handbook's breadth in terms of it speaking to the right in dealing with serious offenses to dismiss on the first offense. But I think it is important to emphasize further that it has never been any party's case that the appellant, to the extent that there was any contractual obligation to follow a process and to have a disciplinary hearing, which we do not accept, it is not denied by anyone that that hearing took place. And there has been no finding by the magistrate to the effect that that hearing was unfair. What we have are findings that the investigation, in the view of the magistrate, was inadequate. And he does not go further to indicate in what way it was inadequate or what further facts he found, if any, at the hearing before him that should have been found by a better investigation. But that is the finding that he found, which the Court of Appeal considered that as an appellate court, it ought not to disturb unless it were manifestly absurd. So our position to that is that arguments premised on any contractual obligation to have a hearing premised on the handbook have to be very carefully treated with, because it is not a part of the facts of this case, in contradistinction to Cato and other cases, that there was any failure by the appellant to follow the process that it impliedly promised its employees that it would follow. So those are the the points I wish the court to consider having regard to the submissions of my learned friend.
Thank you very much, Mr. Koyman. And unless there are questions from my colleagues, it is left for me to thank both counsel this morning for very, very interesting submissions. And we will take all into account, written and oral submissions, and we will reserve our judgment in this matter so that you will hear from us in due course. So thank you once more. Madam Deputy Registrar, you may close the matter.
Thank you, Madam Justice Roch-Nutley. Thank you, Mr. Justice Barrow. Thank you, Mr. Justice Jamada. Thank you, Madam Justice Ononaru, and thank you, Mr. Justice Ebo Suji. Thank you, Counsel, and thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Thank you very much.